A very good morning and welcome to the 16th meeting of the Criminal Justice Committee in 2025. We have no apologies this morning, and our first item of business today is to consider whether to take item 3 in private. Are we all agreed? Thank you very much. Our main item of business today is an evidence session on the issue of non-fatal strangulation. And this includes consideration of the issues raised by petition number PE 2136 in the name of Fiona Drury, who is joining us today. The petition calls on the Scottish Parliament to urge the Scottish Government to make non-fatal strangulation a standalone criminal offence in Scotland. Non-fatal strangulation is not currently a standalone offence in Scotland. Instead, it is prosecuted under a range of criminal offences, and as a result, data on the number of offences which have included an element of non-fatal strangulation in Scotland is not readily available. Since June 2022, non-fatal strangulation has been a standalone offence in England and Wales, and legislation creating a new offence of non-fatal strangulation came into effect in Northern Ireland in June 2023. So, as members are aware, the Scottish Government's 2025-26 programme for government is committed to, and I quote, carrying out a comprehensive assessment of the law in relation to non-fatal strangulation to determine if there is further action that needs to be taken beyond existing provisions in law that could be used to tackle this issue. So, we have two panels of witnesses with us this morning. I'm very pleased to welcome back Fiona Drury, who lodged the petition and is the CEO and founder of Emily Test, Fiona McMullen, Operations Manager with Assist, and Professor Kath White, Medical Director with the Institute for Addressing Strangulation. So, a warm welcome to our first panel members. And I refer members to papers 1 and 2, and I thank those who provided us with written evidence in advance of today's session. So I intend to allow up to an hour or so for this panel, and if I may, I'll begin with a general opening question just to get us started, and I'll come to Fiona Drury first, and then Fiona McMullen, and then Professor White. So, can you explain to the committee what the impact of non-fatal strangulation can be on victims, whether that is in terms of the mental or physical impact, and also in the short and longer term? So, Fiona Drury, I'll come to you first.
Thank you. Good morning. Thank you, convener and members. The harms of non-fatal strangulation are significant, both, as you say, in the immediate term and the long term. We're looking at brain damage, Alzheimer's, cognitive function affected, organ failure and potentially death. It's also, when you consider the psychological impacts, they are extensive too. It's like a near-death experience, and somebody, when they have the oxygen to their brain restricted, they are going to have an automatic response of fighting, literally fighting for their life. So something that is hugely traumatic, and we are sure can have immediate impacts and long-term ones. It's the ultimate act of control, and you know that whether you live or die is down to that perpetrator. His decision, more often it is a he, his decision in that moment, he's going to decide if he lets go or not. It only ends in two different ways. And I'd like to quote some texts, if you don't mind, from my daughter's own case, where members will know that my daughter is no longer with us after being subjected to horrendous abuse. And it impacts us all really heavily, knowing that she was subjected to these harms and these fears. And indeed, you can see that through a couple of her texts that she sent to friends, and this was relating to the non-fatal strangulation, where she said, "I was so scared, I thought I was going to die." And then she sent another one saying, I am so scared that I think I want to die. So we can never underestimate the harms of such abuse. And I'd like to say the perpetrator got 180 hours community service. So.
Okay, thank you very much for that. Fiona McMullen.
Morning, everybody. It's a privilege for me today to hopefully amplify the voices of victims, victims of Assist and victims of the Safe Lives Authentic Voice panel in relation to this issue. So I'd like to just read out some quotes that hopefully amplify the impact of this tactic of control. I've been assaulted, raped and strangled. All of these were terrifying, but it's the strangulation that I feared I wouldn't survive. He says he knows when to stop, but what if the next time he doesn't? I was breastfeeding my 6-week-old baby. I was scared that my weight on the baby would suffocate him. I wet myself. I thought I was going to die. He strangled me and my thyroid went bad. I still have issues with my thyroid. I would take medication to get to sleep and escape the abuse. I would wake up with bruises on my body and marks on my neck. The first time it happened, I was driving home from my mum's funeral. I managed to stop the car. Another time, he straddled me on the bed, knees on either side. He had me at arm's length. I couldn't stop it.
Professor White.
Thank you very much. Thank you for asking me to come and speak here. I could probably talk all day about the impacts of strangulation, but I won't. I agree completely with what's already been said. We would break it down into several issues, so medical, the immediate medical, death, is one end of the spectrum. Your neck is a very vulnerable part of the body. You've got your major blood vessels, nerves, windpipe, etc. So it's very prone to injury. You could have death just because of lack of oxygen to the brain. You could have a stroke later on because the arteries in the neck get damaged. Like any other part of the body, when it's damaged, blood clot forms and then bits of blood clot could break off. So you could have a stroke weeks, months after the event. Nerve damage, we've had people coming in who have paralysis of one side of the face. They have speech problems afterwards, swallowing problems. What we see with some of, particularly the domestic abuse and some of the strangulation in consensual sex, repeated strangulation, repeated episodes of lack of oxygen to the brain, which I think most people would agree is not a healthy situation. So you get a cumulative effect of lack of oxygen to the brain. This is where you might down the line have cognitive problems, difficulties with executive function, making decisions, etc. Psychological impact can't be underestimated. When we've done research, we ask, if I'm examining someone who gives a history of strangulation, one of the questions we ask is, what were you thinking? When we did our research on the adults, over a third said they thought they were about to die. And that is a very rational thought, because actually you are about to die if this continues. So that was mainly women. Even when we asked the men, the numbers are much lower for the men. Again, the rates, around about 40%, thought they were about to die. This has an impact both on their recovery from that event, but also it feeds into this controlling behaviour, because the next time the person might just have to put their hand on the neck and just do a gentle squeeze, because most strangulation is face-to-face, eye-to-eye. There's that mutual shared understanding, as Fiona said, that your life is in their hands. So it's a very powerful way of controlling somebody and what they do. We also know that there's increased suicide in survivors of strangulation. because sometimes they feel that there is no other way out of this. So I'll leave it at there for now.
Okay, thank you. And just one follow-on question from me to yourself, Professor White, and then I'll open up questions for members. So some of the impact that you've spoken about just there and described very powerfully, are there aspects of that which would have some value in terms of more consistent and more effective data recording on non-fatal strangulation? So at the moment, obviously, one of the issues we're aware of is the lack of data, the lack of recording, and perhaps that's an area that needs to be improved. I think we're all agreed on that. But how important would it be to incorporate some of what you have described by way of the impact of non-fatal strangulation into that data collection process?
I would say it's vital, because unless you have the data, you don't know what you're dealing with. So from, first of all, the public have to have an awareness of the issues. If I see someone who's been strangled, I'm thinking medical and I'm thinking criminal justice, you know, wearing two hats. From the medical perspective, it's really important, because if you don't have the history that they've been strangled, or that doesn't follow the person through any medical journey, then there isn't an appreciation of why has this person got these symptoms, or why have they got these signs, or why are they reacting the way that they're reacting if you don't have a history of the strangulation. So, you know, perhaps stroke, or perhaps psychological issues, or swallowing issues. If you don't know that they've been strangled, then you might, and there's not enough awareness amongst the professionals, I would say, with that. We're trying to change that. From a criminal justice process, I think everybody in the food chain needs to have an awareness of strangulation and needs to have an appreciation of its dangerousness in terms of perhaps bail conditions, the seriousness of this. I put it in my written submission about the strangulation being seen as a red flag for future lethality, and that really has to be appreciated. We can't lump it together with the slap or the kick or the punch. It's a different beast, and it has to be treated as a different beast. So everybody making decisions needs to have an awareness that this person's been strangled, this person has strangled, and what that could mean.
Yeah, thank you very much. Okay, so I'm going to hand over to Liam Kerr. Just if I can ask the usual reminder just to keep questions and answers succinct, because obviously there's a great deal of interest in this. Liam Kerr.
Thank you, Convener. Good morning, panel, and thank you for coming and helping us today. It's already very powerful, what we've heard. Professor White, I'd like to come to you first, but obviously other panel members come in or indicate to me, and I'll bring you in. On that last point you made, Professor White, you did submit a very helpful submission, and you specifically said in there that there is a specific standalone offence in England and Wales, and that having that helped elevate awareness of the crime and improved professional and public response. In Scotland, non-fatal strangulation can be dealt with currently under other offences. Now, reading around this and the various submissions, it seems that Scotland could be thought of as leading on this particular issue. For example, I believe in Scotland, the prosecution of non-fatal strangulation isn't contingent on there being an injury or any harm. So let me ask you, Professor White, what is the legislative gap that needs to be filled by a standalone offence in Scotland? Or might there be quicker and more effective ways to achieve the outcomes, such as raising awareness, such as on the bail that you brought up, such as the better public response, that do not require a legislative fix?
I'm not sure I'm best placed to answer because I don't think I've got the expertise on the Scottish law. I would say in England and Wales you don't have to have an injury, which is very important because we know from research that less than 50% will actually have an external visible injury. So it's really important that the law covers that aspect. I suppose the main thing would be counting the strangulation, so having a handle on the numbers, whether that's incorporated into the current law, because it seems like that it's really hard to get the data on the numbers. So if you don't have the data, then it's really hard to know, is there anything making a difference, and how... I don't know in Scotland whether you can track the strangulation cases through the criminal justice process to see is what you've got working.
I'm very grateful, and I think the data point's an important one. I guess my question, and I will throw this to Fiona Drewy, is whether actually it requires a legislative fix or actually there's something that we can be doing that is much quicker and perhaps more effective. Fiona, perhaps you'd...
Yeah,
like
I guess my concern about looking at alternatives and that might be quicker is, are they as effective? So, for example, if it's an aggravator, does it minimise these harms? We are looking at an exceptionally serious crime that merits a law in itself to be recognised as exceptionally high risk. You're 7 to 8 times more likely to be murdered through strangulation. So, as Kath mentioned earlier, it is very different to other forms of abuse. The severity and the outcomes are high. You can't get higher, can result in death. It's the strongest predictor of that. I also would be concerned about how that looks to a victim survivor. Does it minimise what they've been through? We want to make sure that outcomes are proportionate to the crime as well. And it just offers, having a standalone crime offers that legal clarity and precision in the process. Victim survivors recognise that too, rather than an aggravator. And there was a discussion I was having the other day. We have DISTAS in Scotland, so the disclosure scheme. If you are concerned about a partner you have and that they maybe have an abusive past, and then that is disclosed to you and you see that they have got a conviction of domestic abuse, well, we know that can usually be minimalised or trivialised by them. It was just a slap, it was just this or just that. If we have a standalone crime saying that was non-fatal strangulation, I think it acts as a stronger deterrent, a stronger message, and hopefully stops somebody going into a relationship that is exceptionally high risk. So I guess in short, I'm worried that any other approach minimises the severity and risk of the crime and doesn't give victims, survivors the justice that they absolutely deserve.
Thank you. And that's Fiona McMullen. Would you like to?
Could I come in there?
Yeah.
Thank you. Because I think this links to our DATSA legislation and whether we think that's going far enough to capture non-fatal strangulation. And we welcome that legislation. It's gold standard. We were heavily involved in the crafting of the offence. But while the DASA charges are rising, the incident-based response still makes up the majority of reported domestic abuse crimes. So if we look at 23 to 24, only 1,552 reported domestic abuse crimes per DASAs. That's only 5% of the 63,867 domestic abuse crimes that were reported. So it's a reality that we are not allowing for the time and the resources to fully investigate this aspect, this tactic of control, which leaves us with incident-based responses that aren't capturing the terrifying experience and aren't robustly sentencing in terms of them as well. I think we can see, particularly in summary court cases, that the sentencing can be woeful at times, and victims, like never before, are saying, I will not report again. This did not validate my experience and it did not offer me any protection.
I'm very grateful. For the record, when you talked about DASA, you're talking about the Domestic Abuse Scotland Act. For anyone watching. And I'll stay with you, Fiona McMullen, but I suspect Fiona Drew, you'll want to come back in on this. Fiona McMullen, you talked there in very persuasive evidence about incident-based, things being treated as incident-based. The concern that has been raised by Police Scotland in their evidence is that if you create a standalone offence, it might actually lead to a detriment insofar as an incident might be treated as an isolated incident rather than a course of conduct under the Domestic Abuse Act. And they also suggest in their evidence that it could shift prosecution to a specific incident-based approach, and possibly that leads to evidential issues. How do you respond to that? Because that's obviously something that the committee will be concerned about.
It's absolutely a complex issue. What I would say is we have largely incident-based reporting at the moment. And if we consider that we are not capturing the non-fatal strangulation in those reports, then I feel like it can be both. We could have both. If we consider rape and how serious rape is, and that's standalone, it sits out with a DASA offence because of the severity of it. I believe it could be both. Now, I'm not a lawyer and I'm not a police officer, so I get to just say this is what I would like to see. But I do believe that where we can prosecute a DASA, we should, but there would be a merit to still having that standalone aspect of non-fatal strangulation, because at the moment we're failing victims who are not disclosing because they don't understand the severity of it. We've had victims say, what would I show them? There's no marks, or, you know, I wore polo shirts to polo necks to cover it up. So there's something that we are absolutely not getting to. We looked at cases in our own service, and we have 1,250 victims we're supporting just now with multiple court cases. We apply a risk assessment with them because the totality of the risk in the relationship is often very different to what's going through court. So you might have a Section 38 causing fear and alarm, when actually you ask victims a whole load of questions about what's happened to them and you pull out strangulation. In 23 to 24, we completed 1,201 risk assessments. 596 victims said yes to having been strangled. Now, it is absolutely not clear how many of them had that in their charges of assault or within a DASA. We don't have that information, but we know that that would not have captured 596 victims. So this is a tactic that is increasing in prevalence. We're seeing it more and more. It's the most terrifying thing that happens to someone. And if I think about how a victim understands an aggravator or a quicker way to do something, I think we're failing victims in that respect.
I understand. Fiona Drew.
I think Fiona's articulated that really well. I mean, I think it is about failing victims if it's seen as an add-on. This is a common assault with a strangulation, where for people this was the most terrifying event of their lives. I think really there's justification to have that standing as a crime on its own.
Just to briefly add, 223 of those victims were under 30.
Mm-hmm. I'm very grateful to you.
Okay, thank you. Okay, I'll bring in Pauline McNeill and then Rona Mackay.
Good morning. I was first alerted to this issue at a cross-party evening meeting. I think some of us were in attendance, and I learned things I knew nothing about on this issue. And Professor Cathwright, you've talked about the physical impact. What I remember is a statistic from that night was that after 6 seconds of strangulation, you can lose control and become incontinent, and that can be permanent, and lots of other physical issues that you've spoken about. So it's really serious. But what I want to ask you about is what also concerns me. So obviously what Fiona you've outlined, two Fiona's outlined, is the impact on victims and the kind of red flag that it has on domestic abuse. But more alarming to me is that 16 to 34-year-olds indicate in a recent survey that they have been choked or strangled at least once during consensual sex. Half of these young people said they had consented to this. Now, all the data of that age group is showing that they don't see themselves as victims, and it has been consensual. I think it's 27% said it was sometimes agreed, and so on. So we've got I think another dimension to this issue. Now, you will know that in Scots law you can't consent to an assault, and if it's an assault, it is clearly, whether there's consent or not, is currently against the law. So anything you'd like to tell the committee about, I think, is a wider issue that we're dealing with. And obviously it's not exclusive to that age group. I mean, that we've got much smaller figures for the 55-plus group, but it's still there. So we do have a wider problem, would you agree? Fiona, if you'd like to go first.
Absolutely, would agree, and I think it's influenced heavily by pornography and many other social factors that is influencing that. When we say consensual, I always say so-called consensual sex, because they're not consenting to, I mean, as you just said there, to a loss of consciousness, to the bladder incontinence, bowel incontinence. They're not consenting to death. They're not consenting to the long-term harms that we have spoken about, and that's why we really have to raise public awareness of this and make sure that people can make informed decisions, because at the moment I don't think it is informed consent that they're giving.
Can I just add briefly to that? Because of those clients that we looked at, of the 586 out of the 1,201 clients that suggested strangulation, only 18 of them, I'm not saying we don't have a problem with this, but if we think about, I'm talking from a domestic abuse context, 18 of them said that it was during sex, only 18 of them. And 2 of them said that was consensual and taken on board where consent lies in a coercively controlling relationship, and 16 said it was non-consensual. But the vast majority, understandably, given that I work with domestic abuse victims, the vast majority were experiencing that in the context of very much coercive control.
Just to add, my background's the sexual violence. Of course, there's big overlap between domestic abuse and sexual violence. And this goes back to some of the earlier discussion about the DASA, because that would cover the domestic abuse, but a lot of strangulation is happening outside of domestic abuse. It certainly is an issue, the rise of prevalence of strangulation in so-called consensual sex. And I think the figures you quoted were from the IFAS survey, and we're just about, which included people from Scotland, and we're just about to do a much more in-depth survey. We've just had a paper accepted on child strangulation. So this is children who have disclosed rape or sexual assault, and they give a history of strangulation as part of that. So we had 91 children. Now, over a third of the alleged perpetrators were children themselves. So this is certainly an issue that is creeping into more than the adults in the domestic abuse setting.
Thank you very much. I will explore that issue further, because this is the, I mean, any kind of anecdotal evidence would suggest it's not even particular to men and women, but I don't know, haven't seen the data for that. But I agree with Fiona Drew on this. I think there's a deeper issue about the impact that pornography is having, but I'm not certain that it's gender specific, because I just don't know. Because even though women are agreeing to it, we don't know why they think it's okay. So I'm clear that public awareness is really important, and thank you for the work you've done on it. The question of legislation that Liam Kerr's also asked you about, just a scant look at the English legislation seems to me to be flawed, because if there's a defence of consent, then you can see these cases are going to fall. And I would have thought that it's more important to, initially, to do a lot of high-profile campaigning around whether you consent or whether you don't. There's harm caused. And whether you think it should be a standalone offence, if you put that to one side, it is currently against the law. But clearly, many people don't think that it already is. So I suppose my question is, well, if we were going to create a new offence, I see flaws in the English legislation because of that. I wonder if you agreed. And before we made any decision about the enactment of the law, we're going to have to deal with people who think it's currently lawful to do this. So anything at all you want to respond is fine.
I'm happy to come in. Looking at, I always think it puts us in a more fortunate position that we can look at other jurisdictions and look at the weaknesses in their existing laws, and we learn from them and ensure we do better. So I absolutely agree that we can't just basically lift it off the shelf from another jurisdiction and put it in place here because the laws are different. But I don't believe that would be a reason not to do this. I think we should seek the solutions for that. And absolutely, these discussions like this and discussions with colleagues and COPs and Police Scotland are absolutely essential, legal experts, so that we get this right and we don't unintentionally dilute any of the existing laws at the moment.
Fiona or Professor Cathwright?
Do you want to say something, Fiona? With the consent, I'm not a lawyer, but my understanding is you can't, in England and Wales, you can't consent to something that does you serious harm. So there is a defence of consent, but if somebody was reckless, you know, that wouldn't stand. But I think you're absolutely right that regardless of the legislation, there's a whole public out there doing things, and I think there is a big need for education about strangulation, about the risks of strangulation, so that people make informed decisions. And Baroness Gabby Burton did the pornography review. We had some input into that about banning strangulation in pornography. So I think there's other measures need to run in parallel, whether you change the law or you don't change the law.
Can I?
Of course, yes.
I'll bring it back. Obviously, I'm here to think about domestic abuse, and this is a repeat crime, domestic abuse. It's unique and quite distinct in nature, and there's something for me when we talk about campaigning. I think campaigning is really important, but if we think of a perpetrator of domestic abuse that feels absolutely entitled to take someone to the brink of death and let them go or not, then I think that needs to come with consequences. And if we look at successful campaigns that are not related to domestic abuse, whether it's wearing seatbelts, driving under the influence, they came with consequences.
Absolutely. Thank you very much.
Okay, thank you. Rona Mackay and then Sharon Dowie.
Thank you, Convener. Good morning, panel. Fiona, I wanted to ask you, and this is aside from our discussion about whether it should be a standalone offence or not, do you think that during domestic abuse prosecution it should be a standard question that's asked? You know, it should be a standalone question as part of that prosecution. Would that be helpful?
I think it would absolutely be helpful, and at all levels. I mean, from when you hear of a crime disclosed that is related to domestic abuse, I think the question should be asked. Indeed, if you look at some of the specialised risk assessments that's in there, and the police should absolutely be asking that, and therefore that would carry on to a case. Is it always asked? I'm not too sure. There's not any conclusive evidence that it's not, but there is suggestion that it's inconsistently asked. And could this law bring clarity? Also, if it is going to be mentioned, how are victim survivors feeling that that's something that's relevant? If it is, say, an aggravator as an add-on, you know, they don't actually know that something like that has happened to them. So it's about raising awareness of it as well, so that it does come up in that case.
Yeah, that was my thinking was at least it would raise awareness during prosecution that had happened. Fiona, do you have a view on that?
That should be happening just now. The police, when they go to domestic abuse incident, will be offering the same risk assessment that I spoke about to every victim. Whether they complete that is taken in a time of stress and distress, then they might not always complete it. But question number 15 asks, have you ever been strangled, choked, suffocated or drowned? Right? So it's way before prosecution for me. But what are we doing with the yes answers? Right? We need the resources, the knowledge, the skill and experience to probe that question. In our service, that question, a yes response to that would be how often, to the point of what?
Yes.
Yeah. Where does it happen? What's used? Is it a belt? Is it your hands? Because if you try to safety planning against non-fatal strangulation, it's completely different than safety planning against an assault. In an assault, we say stay away from the kitchen, from knives and sharp objects, stay away from the bathroom with water and hard surfaces. Ultimately, if you can't get out, get yourself to a bed or a couch, somewhere soft, because that will absorb the hits and the punches. You cannot safety plan effectively against non-fatal strangulation.
And I was interested in your opening comments about the case where someone was in the car coming home from their mother's funeral or whatever, and that you just don't imagine that would be the setting for that, because that's completely so random and horrifying.
There was another quote for a victim who said it happened on the night of her honeymoon. But there's something for me about someone is straddling you at arm's length. You have no way of escaping. It's quick, it's silent, and it's terrifying.
It's effectively like attempted murder, isn't it? Yeah. Can I ask you, and I'm not sure if you'll know, but it's about the legislation in England and Wales, which was, I think, 2022. It was introduced there as a standalone. So has there been an increase in reporting of the prosecution? What are those figures like following the introduction of that legislation?
So it showed in the first 6 months from June to December that there were 8,375 non-fatal strangulation offences reported, and there were 971 charges. They're actually seeing that the conviction rate of non-fatal strangulation is slightly higher than the conviction rate for domestic abuse. So I think that's certainly something we should take into consideration. I'm not sure if colleagues have got more information on
that. IFAS have done several freedom of information. We've got another report that we're just about to publish. So in the first year, we have the 6 months data Fiona's just mentioned. Then in the first year, it was 23,000 roughly. Police reports, and then this last year that had jumped to 39. Now, you have to be careful because there were more police forces reported the data. So we've also broken it down into looking at population sizes. Big disparity in the different police forces in terms of rates of police reports. Still a lot of work to do because the latest data is roughly 70% don't progress because of evidential difficulties. What does that actually mean? So I think there's quite a lot of work to be done.
I was going to follow up on that because it seems like the numbers that Fiona quoted, there does seem to be a lot of not proven, for want of a better word, cases or cases that didn't, that they didn't result in charges. So is there a problem with actually identifying it and improving it?
I think that there definitely is. There's improvement, there's increased awareness of it. Sometimes it gets lost because it'll be an accounting issue, or there might be higher charges like attempt murder, so the strangulation kind of gets lost in that. We've done a few exercises with different police forces where they look at strangulation cases, and we still sometimes have police officers going to a home and saying there's no injury, therefore. So there's a lot more work to be done with it. But at least we have some of the numbers and we know what to aim for.
It sounds like more training and awareness, obviously, that's a given, but training for, for police as well needs to be there.
I think there's lots of issues. So that there's training. I think it's support for complainants as well, to make sure that they are supported through a criminal justice process. You know about the delays in criminal justice cases. So there's a whole myriad of reasons why people, withdraw.
Yeah. Okay. Thank you.
Sorry,
Fiona. Yes.
I guess I absolutely see that there is going to be a challenge with lots of cases like of gender-based violence, but looking at the evidence, there may potentially not be any marks. This is why the response has to be right. We need to make sure, that if they can, that victim survivor can go to accident and emergency afterwards, and they can get their Kath would be better to explain that than I, but they can get their oxygen levels tested, and then you can gather evidence that way. And also, because most of these things happen behind closed doors, we should never forget hearsay evidence.
Yes.
So in our daughter's case, she had told someone. So that's your hearsay evidence. She was no longer here to speak for herself. Yeah. So I think that's probably for colleagues this afternoon that could maybe expand on that a wee bit, but it's certainly not impossible.
Yeah, that's interesting. Thank you. Thanks,
okay, thank you very much. Sharon Dowie and then Katie Clark.
Thank you. Good morning. I went to the round table in non-fatal strangulation as well, and one of the questions I'd asked at the time was, do we currently have legislation that we can prosecute? And the impression I got of the answer was that we do, but it wasn't highlighted often enough. So that's what my question is. Do you think the Scottish criminal justice system is able to adequately investigate and prosecute this behaviour under current laws? And if not, what would be the benefits of the standalone offence?
I suppose it takes me back to what I said about the vast majority being incident-based reports, that you would hope there would be more exploration of, whether the resources and the skill and knowledge are there to support that. Often what we do in our service, with a criminal court domestic abuse advocacy service, is work with victims who've reported to the police. We redo the risk assessment that they might have done with the police. We will often get additional disclosures, and we will absolutely encourage them to go back to the police, particularly when they talk about strangulation and other criminality. We also talk to them about the worsening conditions that we've heard about that might not have been apparent at the start. So do I think that with the number of DASA offences that we see coming through that are ultimately rising, we're capturing the assaults with the non-fatal strangulation in them? No.
And I think it's how are people identifying that this has happened to them and the severity of it, because there is little public awareness. And so sometimes people will say, you're not going to say it was strangulation. Sometimes they'll say, well, I just pushed my hand against their collarbone, or... And I mean, the majority of strangulations are one-handed, so they don't think that it is strangulation because there are no two hands round the neck. So it's the way that people perceive it and interpret it that a standalone crime can help. They can start to educate the public and educate victims and survivors, and hopefully deter perpetrators.
So do you think more education for
Absolutely.
Police and for the public would help? And I'm still trying to get to whether or not we would need the standalone offence, or whether, because I think, as Liam Kerr had said earlier on, Scots law was already further ahead, so we have got ways that we can prosecute it. And I know there was concerns that the current laws could be diluted if we brought in the standalone offence. So would more education of the public and of the police help, or do you still think there definitely needs to be a standalone offence?
I think it would help, but it wouldn't go far enough. I think it's as simple as that. You know, I think if you're speaking to any victim survivor and this is seen as an add-on, so it's an aggravator, or however they would intend to prosecute that, I mean, that really feels as you have just had a near-death experience minimised. And that leaves that perpetrator to carry out significantly more harms too, as we've seen with some of the sentencing. But I don't think it goes far enough. We're going to educate the public, but say, well, it's not a standalone crime. I think there's a big message in that alone that's quite concerning.
Interestingly, one of the victims I spoke to this week from the Authentic Voice panel said to me he didn't see that as a crime. He wouldn't punch and kick me, but he didn't believe strangling me was a crime. Now, it absolutely is, all day long, but his view of it was that it wasn't. So I think there's something for me about we can change internal policy and procedures, we can raise awareness, but we absolutely need to capture this at the front line, and it's not working to the extent we need it to just now for many complex reasons.
Okay. My second question. Police Scotland and COPS raised concerns in their written evidence around potential detrimental effects from introducing a standalone offence of NFS, where it would be treated as an isolated incident rather than as part of a course of conduct under the Domestic Abuse Scotland Act 2018. So what are your views on that? I think they, again, as I said before, they thought it would maybe dilute what we already had.
I think, again, it's what I said about can we have both? Can we have still the opportunity to go with a DASA? But, and again, I'm not a lawyer or a police officer, but we're not capturing it in our DASAs. 12,000 odd reports of DASA offences versus 63,000 odd domestic abuse crimes. We're not doing it just now.
And I think the point that Fiona made earlier is, well, why would we not do that with rape? Because we know the severity of the crime. Is that suggestion showing our lack of knowledge and the severity and the risks that come with this crime?
The other thing to remember is not all strangulation happens in a domestic abuse context. So however good your domestic abuse laws are, it's not going to help those where it's happened in a different context.
Right, okay, thank you.
Okay, thank you. I think, Fulton McGregor, did you want to come in with a follow-up to Sharon's first question?
I'm not one to stand on MD's toes. If Katie Clark's before me, it's a general question.
I'll bring in Katie Clark and then I'll come back to you, Fulton, if you still want to ask a question.
Thank you very much. And we know from other issues that we look at that the fact that some behaviours are criminal offences doesn't necessarily mean that they're fully investigated, that there's prosecutions and indeed convictions. So I was going to ask quite a general question in terms of, are you satisfied that in Scotland, that when matters are raised with the justice authorities, in whatever way, usually the police, that there are serious attempts to prioritise it, to investigate and to take charges where that's possible? And I mean, we know there's been mention of evidential problems in terms of actually securing convictions or actually getting as far as the court. And, for example, in rape, we know that there's legal developments regularly in terms of the evidence that's needed to secure a rape conviction, for example, around about corroboration or other issues. And if we are either going to keep the existing law or indeed create a new offence, the framing of that offence is very important in terms of what's required to prove it. And I just wondered if you've given any thought to what you're looking for in terms of improvements in the law that would lead to prosecutions and convictions, whether that's with the current range of offences that we've got, and aggravated attempted murder has already been mentioned as a charge, or whether it's a standalone offence. What would that look like? What are you looking for, would you say? What should we as a committee be pushing for in terms of the content?
Do I think there are enough police resources currently to explore this fully? When someone says yes to question 15, no. What I would want to highlight, though, is victims come into the criminal justice system often after managing this for a long time by themselves. The criminal justice system alone and the outcomes of court are not the only thing that's happening there. And again, the totality of risk can look very different. So we can have a victim going through a summary court case and it doesn't capture the totality of the risk. But bear in mind that that report to the police brings other things into force. So it brings a coordinated community response with our multi-agency risk assessment conferences. It brings in support from organisations like myself, my organisation, that will help to support with increasing safety and well-being. And there's something for me there about where what's happened to the victim follows them to other processes. So again, if we're discussing a case at Marac and we're talking about a victim who's been non-fatally strangled, that's very different than the safety planning we would do around a victim that is being assaulted. So I don't know if that makes sense, but there's something bigger for me in what the criminal justice system and all the different components is actually providing. So there's more to it than that court case. It's got, you know, if we think about very many victims end up with a criminal court case and a civil court case running alongside. And you're taking what's happened to you criminally into that civil court where decisions are being made about child contact and the safety of that. Then I think there's a distinction there to be made about what someone's experienced and how seriously we view that.
Fiona?
I don't think I've got anything to add to that. I think, I mean, I'm aware of the complexities and ensuring in conversations we've had, we don't want to dilute anything that is in existence. I just think it's really important to show that we understand, fully understand as a country, the severity and risks that this crime carries.
But in terms of the standalone offence, you'll know that we've created other standalone offences that sometimes are not used as often as we would have expected them to be used, and there's reasons for that. So the way that it's framed and the scoping is really important, and I appreciate we've got another panel that might focus on that, but it's just whether any of the panel have a view in that, because there, you know, we could create a standalone offence, but it may not make the difference that you're expecting.
I think one of the, and I suppose that's what it links to me, it might not make the difference every time in that court case, but it might make the difference in how we proceed with supporting that victim and holding the perpetrator accountable within the criminal justice system. But I was also going to say that one of the successful standalone offences I think we've seen is stalking, the Section 39, and that absolutely has increased awareness, and it has come with consequences for perpetrators and for validation for victims of the horror of that experience.
Okay.
Yeah, and I guess I agree. I agree with Fiona, as I've said throughout. You know, the evidence that I think this public awareness is really key in educating the public and hopefully it acting as a deterrent too. I understand what you're saying about some standalone crimes potentially not, you know, securing a successful conviction, but we shouldn't let that deter us from trying to make improvements, and as we go, tweaking them for maximum, you know, efficacy as we go forward.
One of the issues that I think we've had in England and Wales is the absence of services for complainants. So if you're sexually assaulted, you can go to a sexual assault referral centre, you get your forensic medical examination, and then all the follow-on that goes with that support through a criminal justice process. In England and Wales, if you are strangled in the context of domestic abuse, there is no specialist service for you. You might get sent to A&E, you might get sent to the GP, who don't have the time, the capacity that a SARC has. So I don't know what it's like here in Scotland, whether you've got domestic abuse referral centres with the same way. And I think the other thing we're concentrating on the complainant, but I think it's important that this crime follows the perpetrator as well, and that they're marked because it is different from other types of abuse, and they have to be seen as a higher risk. So I don't know whether that is covered currently here.
Okay, thank you very much. Fulton McGregor, do you want to come in, or are you happy with what you've heard?
No, thanks, Convener, if that's all right. So I think that all the panel spoke about the issue of public awareness, and it strikes me in this panel today as that's really, really an important issue. Has there any thought about how we might do that? And I wonder if rather than repeating maybe things that you've said earlier, I wonder if you'd any thought about how the message can be put out there, particularly to young boys and men, because I think that they are obviously the target group for, you know, getting the message out there, rather than putting the responsibility onto women and girls to not engage. And I think, I mean, they obviously need to know about it as well. Everybody needs to know about it as a point of public awareness. But is there anything that you've thought about how we can get this message out there to young men and boys particularly?
I think it's obviously education, and education at as early an age as is possible. In Emily Test, we go into schools, and it's usually people of the age 16 and above that we'll speak. We usually tell Emily's story, and we'll talk about non-fatal strangulation and the pressures around young people to conform to that and the normalisation of it in our society. So absolutely helping them to understand the harms and the risks that we've spoken about here today is essential. I would always find that quite uncomfortable if I was to go in and try and educate and then say, but it's not a standalone crime in our country when it is in every other country in the UK. That, I think, could be problematic in terms of us trying to assert that this is an exceptionally dangerous crime.
Just to add to that, I absolutely agree with the education, particularly targeting young people, but in those 586 yes responses to have you been strangled, I was really interested in 197 of them being 31 to 40, 9 of them being 61 to 70, and 1 of them being over 71. So while I absolutely appreciate that there is a need to target young people, we also don't want to lose sight of this happening to people of all ages.
I think that's a fair point as well. And one other question that follows up, Professor White, in your last comment there when you said about there's got to be a way that the offence of strangulation or the risk that poses has to follow the perpetrator as well. And I found that actually very interesting. Before I became an MSP, I was a criminal justice social worker. So it was a while ago now, going on 9 years ago. And I have to say that in thinking back to it, I don't ever remember particularly that being a particular issue that we took into account in risk assessments. Might have changed now, so I'm willing to say that, you know, in case I'm wrong on that. But there is possibly an area of work to be done there with the criminal justice social work services to ensure that they are recognising that as a risk factor for future offences. So perhaps even allegations of it, because there is other allegations, types of behaviour that criminal justice social work would take into account in terms of planning around possible future offending. But I don't think I'd really come across that to any great extent. So I just wanted to say that I think there's some work we could possibly do there.
I completely agree with that. Also thinking about, well, every aspect of our criminal justice system. You've got someone in prison serving a sentence, they're not released under the 50%, but they're entitled to apply for home detention curfew. The Governor's looking at that and saying that person's been convicted of an assault on a woman. That sits quite differently to me when you're making that decision, and that victim has been a victim of a non-fatal strangulation attempt. That would say something different to me in terms of whether or not that person was more dangerous to release on that home detention curfew. So I think there is a lot to be done in every aspect of the criminal justice system. I also think that when we look at this repeat nature and perpetrators going up in front of a sheriff again and again, potentially for different victims, we see really robust sentencing, but we wait until we've got 5 or 6 victims that have had 9, 10, 12 years of abuse before they attract those significant sentences. I'm not for a minute saying I want everyone to get custodial sentences, but again, a sheriff looking at previous convictions and looking at a previous conviction for assault versus a previous conviction for non-fatal strangulation of another woman might sit differently.
Fair point. Thanks. Yeah.
Thank you very much. Okay, so that kind of brings us up to time. Can I thank our witnesses this morning for your contributions? I think that's been a really helpful insight into this issue, and I think it goes without saying that people who have been perhaps watching this session may be affected by what's been discussed. So just a reminder that the Emily Test website is there, and it includes guidance and training material, and it can be found at emilytest.org. I think I'm right in saying that. So obviously that is a very useful resource for people to access. So with that, thank you again to our panel members, and we'll just have a short suspension for around 10 minutes just for a comfort break and a changeover of witnesses. Thank you very much. Thank you. Okay, thank you very much indeed. So I'm very pleased to welcome our second panel of witnesses this morning. We have Dr Emma Forbes, National Lead for Domestic Abuse at the Crown Office and Procurator Fiscal Service, Liliana Torres Jimenez, Criminal Policy Executive and Secretary of the Criminal Law Committee of the Law Society of Scotland, and Detective Superintendent Adam Brown of Police Scotland. We also have Detective Superintendent Lindsay Fisher, Public Protection Branch of the Police Service of Northern Ireland, who is joining us remotely from Belfast. So a warm welcome to you all, and thank you very much for your time this morning. So I intend to allow around about 75 minutes or so for this panel. We may have to make it slightly shorter, and I am aware that we have one or two little technical issues. On the back of my first question, my opening question, I'll probably bring in Detective Superintendent Fisher first, and then I'll come back to the witnesses in the room. So I'm going to open up with the same opening question that I asked the first panel, and it was just to ask if you can give a view on how you think we should best tackle non-fatal strangulation in Scotland, and do you think the legal framework and the powers available to police forces are adequate? So I'll come to Detective Superintendent Fisher first, and then I'll come to Dr Forbes, Liliana, and Detective Superintendent Brown. So Detective Superintendent Fisher, over to you first.
Thank you, Convener. Thank you, panel. I think as I listened to the first panel, there was a lot of discussion about standalone offences, and whenever PSNI introduced the non-fatal strangulation offence in Northern Ireland almost 2 years ago, this was a standalone offence, with our previous offence being quite complicated and complex in nature. Not only did we have to show the strangulation or the choking asphyxiation aspect, but we needed to show the intent to commit a further indictable crime. So certainly for Northern Ireland and for PSNI, the legislative landscape and the improvements that having a standalone offence have been immense. We have seen, and we continue to see, an increase in our operational figures, and I'm sure we'll touch on those a little later. But to set the context, within 3 days of the legislation going live, we had not only used the new standalone offence, but we had somebody appearing in court having been charged for it. So I think that in itself shows the need, the understanding, and also the drive to use this new offence to the best of our ability. Like in the previous panel, there remain some challenges, and again, I'm sure we'll discuss those further. But I do think that it is important not only for outcomes in a criminal justice sense, but actually in understanding and in listening to victims, survivors, advocacy groups, to really highlight the importance of non-fatal strangulation, and sadly how we see that translate into future domestic homicides. So I think it's really, really key that we do look at the legislative landscape, and whilst initially it may be an offence that isn't used as much as we had particularly anticipated, that with the public awareness, with the media attention around convictions, I do think that that would steadily increase.
Okay, thank you very much indeed for that. Okay, I'll just come straight to Emma Forbes.
Good morning, Convener. Thank you for having me. It's been a privilege this morning to listen to Fiona and the other panel members speak. I think that it's so important that we humanise what we're doing, and that we remember the impact that this is having on people's lives and just how terrifying it is. Within Crown Office and Procurator Fiscal Service, we are worried about the albeit anecdotal at the moment, evidence that we're hearing about increased prevalence in society, particularly amongst young people, but across all age groups, as Fiona has said. And we want to respond to that. I think my role here this morning is to hopefully try and explain how we prosecute it at the moment. Strangulation is lethal, and it is a crime that we take very seriously. We can use a range of offences to prosecute, but unlike what Detective Superintendent Fisher has said about the landscape in Northern Ireland, it's not complicated. If it's not within a domestic abuse setting, it's open to us to use a range of offences. So, attempted murder, we would be using common law offences. An assault, it is an assault. You can't consent to an assault in Scotland. There is no defence of consent. There is no legal wrangling or discussion about whether or not the victim consented. I think that's crucial to this debate. My understanding from reading some of the really helpful research that's come out of the Institute for addressing strangulation is that around 86% of strangulation is within a domestic context. Mm-hmm. So if we look at how we handle those cases, then we would seek to prosecute those in terms of Section 1 of the Domestic Abuse Scotland Act. Now, that legislation passed in this Parliament building to a standing ovation by all MSPs to the third sector in 2018 and came into force in April 2019. It's established in our law now, but it is still relatively new legislation, mainly because of COVID-19 restrictions and people literally being locked into relationships and the prevention of reporting. But we have seen an incremental increase year on year. I would have to acknowledge what Fiona McMullen said earlier this morning in evidence, that a large proportion of domestic abuse is still reported as incident focused. We are working really hard with our third sector partners and with Police Scotland to try and mitigate that, and I think you can see that commitment is echoed by Police Scotland in their written submissions. So the Domestic Abuse Scotland Act Section 1 is world-leading legislation, and it is completely unique. No other country in the world has legislation like it. It allows us to prosecute a single offence of a course of conduct, and that is in recognition of the way that domestic abuse is perpetrated. It acknowledges the dynamics of that, as Fiona called it this morning, unique dynamic of offending. And Fiona mentioned earlier the fact that we can prosecute a Section 1 DAS, a course of conduct offence, and then separately prosecute a rape charge. And that is true. Sometimes we would include it within the body of the DASA charge, and sometimes it would be a standalone offence. It would depend on the way in which the offences took place. Mm-hmm. But this is different again. This is something that we know to have lethal consequences. And as prosecutors, we are keen to be able to tell the court the whole story of what has happened to an individual victim. And if the consequences are the absolute worst, then we want to be able to present all of that evidence as one course of conduct, one of that is all domestic abuse. It all stems from domestic abuse, and we want to be able to prosecute all of it as one single offence. We are trying to move away from incident-focused policing. In preparation for coming today, I did look at the Domestic Abuse Scotland Act cases that have been reported to us from Police Scotland over March. So forgive me, I'm better with words than numbers. But we received 155 Section 1 reports during March. We have marked 136 of them, and we are still conducting further inquiries in relation to 19. So of those 136 DASA cases that we have marked for prosecution, none of them were marked insufficient evidence, echoing the evidence we heard this morning about 70% of cases for the specific offence in England and Wales not proceeding because of a lack of evidence. So we have marked all of them for prosecution, and 38% of them featured non-fatal strangulation. Mm-hmm. So just shy of 40%. 49 of the perpetrators were male, and where the 2 perpetrators were female, it was also still a female victim. All the victims were female. Mm-hmm. So I hope that that is a small illustration, at least, of the fact that we have effective legislation at the moment. I definitely think we could be doing more, but what we're deciding here today is whether, what you must decide here today is whether the foundations of what we have are fit for purpose or whether those foundations need to change. And there are compelling reasons to create a specific offence of non-fatal strangulation, because overnight you will raise public awareness, which urgently needs to be done, and it would also make it easier to count them. We need to count and we need to raise awareness, and this is a public harm. But we have a very strong foundation in our law in Scotland, and I would worry about the unintended consequences of a specific offence, not least because it would be more difficult evidentially to prove.
Thank you. Thank you very much. It's a really comprehensive overview, very helpful. Liliana, can I come to you next?
Yes, thank you, Convener, and good morning to all the members of the panel. I think I will echo many of the comments made by Dr. Forbes. I think she made a very good and comprehensive comment about the available offences right now for non-fatal strangulation incidents. I just want to mention maybe some international evidence that we found regarding non-fatal strangulation in other jurisdictions, and we were able to find that after the implementation of non-fatal strangulation legislation in some American states, it was reported at least 3 positive impacts. One of them was addressing the gap that was in that legislation. The second was the education of the community in the impact of non-fatal strangulation incidents, that I think it was mentioned already by some of the members of the previous panel. And the third was, of course, a positive impact in the safety of the victims. So we think that it can be a merit in introducing legislation for a statutory offence of non-fatal strangulation. As well, it will, as it was mentioned by other members today, that it will improve the number of cases recorded and the statistics available. But I think for seeing all those benefits, appropriate resources should be allocated in the implementation of any potential legislation. We'll listen today that, at least from DASA, there were some comments about the resources for appropriate investigations and risk assessment for victims. And also, we listened from the experience of England and Wales. The resources were very important in terms of awareness and training of the police and prosecutors, and of course for the support of complainers in those cases. So, I think it can be merit for creating a statutory offence. I think a thoughtful consideration should be given to the matter of the resources for future implementation and the resources that are currently available for the current legislation. And if those are, I don't know, if they should be divided into a new offence or they will be just immersed in the current legislation that we already have.
Much for that. Detective Superintendent Brown, over to you.
Good morning. Thanks, Convener. Thank you for having me here. So I couldn't probably articulate it much better than Dr. Forbes in respect of our view. I'd like to start by talking about the prevalence of this, and we've talked somewhat this morning about the difficulty in extracting data. I think that's a very fair point, but having been a detective specialising in domestic abuse here in Edinburgh before taking up this post and a MARAC chair, I think it's fair to acknowledge that this type of behaviour is prevalent in abusive relationships, and we need to take the accounts of our partners in good faith. We've long recognised the harm of non-fatal strangulation in our risk assessments with victims of domestic abuse. Fiona McMullen mentioned question 15. Incidents, regardless of whether a victim's reporting a crime or not, incidents where they're referencing non-fatal strangulation will be subject to a review by specialist officers and potentially follow-up in terms of what needs to be reported or what safety planning needs to be completed. So we've long recognised the serious harm and the consequences that have been articulated by other panels this morning. Any concerns we have around a standalone offence come very much, as Dr Forbes articulated, from the practical implementation of that and the potential unintended consequences in terms of our overall response to domestic abuse. I think we'll have to acknowledge that despite having been frustrated by COVID, that there has been progress in how we've addressed domestic abuse over the last 5 or 6 years, and it's important to recognise the efforts that as an organisation and along with our partners we're putting in to training and development in this area. However, when the police don't get it right, a prevailing theme is that we are reverting to incident-based approach, and that will be reflected in our HMICS inspection. It's reflected in our own victim survivor feedback function through our website, and it's also reflected in feedback from partner agencies. So on those occasions we're not getting it right, and Fiona McMullen did reference that, it is that focus on incident-based approach that causes concern, and we would have concerns that a standalone offence would remove non-fatal strangulation from inclusion in investigations into Domestic Abuse Scotland Act offences and make those investigations and the charges that come as a consequence of that less robust. And I think when we talk about incident-based reporting, I think focusing on that and risking a backward step in terms of our approach in that respect has the potential to be very frustrating for victims when they're engaging with the police, and we'd be concerned about potential disengagement as well. Having said that, we'll absolutely welcome an opportunity and thank Fiona Dree for putting this in the spotlight, because we fully recognise the harm that it causes, and we are committed to work with our partners around those pieces of education, awareness raising, and obviously we'd welcome measures in law that fully recognise it when it comes to consequences for perpetrators.
Okay, thank you. I wonder if I can just stay with yourself, Detective Superintendent Brown. Just one quick follow-up question before I bring in Liam Kerr, and we've spoken this morning about DASH, the risk assessment process that I think I'm right in saying frontline officers will complete, and so that early gathering of accurate and robust information about the circumstances of an incident is really crucial. And we've spoken about question 15, which relates to strangulation, choking or suffocation. In your view, from a Police Scotland perspective, is there scope perhaps for that question, given, regardless of whether we do ultimately create a standalone offence or not, but given just the significance of that particular act, is there scope for that question to be expanded or developed to be perhaps more effective, if you like?
So I think it's about who's using the tools rather than the tools we have, and I think ability to expand on that question and probe it sensitively with victims comes with training and experience, and that's where we'd like to focus our attention. It does form it's one of a series of questions that we ask in that risk assessment, and it's not done in isolation of other considerations. So typically it would be done by our frontline officers, but it would be revisited potentially by specialist officers, and obviously that would also be reflected in the reports in the Crown Office and Procurator Fiscal Service, as well as referrals into our partners. So the expansion of that question comes through a combination of those different processes, rather than just an expansion of the standalone question that the frontline officers are delivering.
Thank you, that's really helpful. Okay, I'll bring in Liam Kerr and then Pauline McNeill.
Thank you, Convener. Good morning, panel. Detective Superintendent Brown, I'll go to you first. Could you explain briefly for the committee, just so we understand, how an offence, either solely of non-fatal strangulation or an offence that involves that behaviour, would currently be investigated and prosecuted? And the reason I'm asking is, at least in part, because of your earlier answer. Don't you already just investigate all possible crimes, regardless of what ultimately will appear on the indictment?
Well, yes, of course. So the starting point is the account of the victim that's being provided to the police. So it would be exploring the circumstances, and there can be a range of outcomes in terms of which officers would pick that up. In cases where non-fatal strangulation is present, particularly in domestic abuse cases, they would invariably come to the attention of specialist domestic abuse units, and with specialist detectives going out and taking statements from those victims. Those cases tend to be more complex, they tend to be more long-term, so they would be reported. They'd be reported into the Crown Office and Procurator Fiscal Service accordingly, drawing on all the additional resources we may need. If it's an acute report of non-fatal strangulation, that can include forensic medical examination, documenting of injuries. We did hear this morning that injuries aren't always apparent, but the inclusion of that in a DASA in particular doesn't require specific evidence of those injuries or specific corroboration for that act on that particular occasion, which makes it a particularly useful tool when it's used well in addressing it.
But why would a standalone offence preclude the taking of all of that evidence at the investigation stage?
Well, it wouldn't. We would still investigate much in the same way, but I think in terms of the broader context of the abuse, I think it was possibly not helpful to focus in on that incident-based approach. Regardless of what offence we're investigating, these investigative tools are always available to us.
Thank you. Dr. Forbes, so moving on in our case that we're looking at, you heard the evidence this morning that there's at least an argument that under the current system, that if you have, there's a failure for victims, because what we've got is a common assault with a kind of add-on of non-fatal strangulation, and that optically for a victim and optically for the alleged perpetrator is not good, because it downgrades the non-fatal strangulation bit. The suggestion was that it would be better if the charge would be, you could have a common assault with the non-fatal strangulation, but also a non-fatal strangulation standalone offence. Wouldn't that be a better way to proceed? And if not, why not?
So it is, one way to proceed is to create a standalone specific offence. The advantages to that in terms of the prosecution in court are, as you've said, that there is a strong public message of the seriousness and wrongdoing, and given everyone's shared concern, then that is a compelling reason. However, if we have a standalone specific offence, then we have to prove that non-fatal, the act of strangulation, by corroborated evidence. Now, presently, if we include it in, so it's very seldom that we would see a single strangulation with no other offending. That would be relatively rare. And given that the vast majority of the cases reported to us, the non-fatal strangulation is part of a course of conduct of offending behaviour, then by prosecuting it in that course of conduct offence, we just have to corroborate the course of conduct, not each aspect of it. Does that make sense?
It does. My question really, though, is, in the case, the example we heard this morning was that by having a separate charge of rape, it shows the severity of it, but having that charge doesn't preclude other charges being prosecuted. So am I right then that if you have, that you could indict both a standalone offence of non-fatal strangulation and the common assault charge? You don't preclude one by having the other, or do you?
So if it was a common assault charge and the only, not only, but the narrative of the offending was the non-fatal strangulation, no, you couldn't prosecute both because you'd be prosecuting the same thing twice. What Fiona McMullen was describing this morning was a Section 1 DASA where all of the coercively controlling behaviour was narrated within the body of a DASA charge, but that we pull the non-fatal strangulation from that. We don't include it even though we all know it was part of that course of conduct, and we prosecute it as a separate offence. Now, I understand why she suggested that, and I understand the declaratory power of doing that and of the public statement of saying just how wrong that is. But the unintended consequences of that are, A, it's much harder for us to prove. And if you look at the statistics from America, the Florida study, so they've had their legislation in place since 2007, I think. And a study as recent as 2020 showed that the vast majority of cases were not taken forward due to lack of evidence. And we've heard evidence in this committee this morning about the fact that in England and Wales, evidence is an issue. We also heard that there was slightly more higher conviction rate for non-fatal strangulation in England and Wales than other domestic abuse cases. But our conviction rates in Scotland and the way we prosecute domestic abuse in Scotland has already been recognised by English academics, I hasten to add, as being the global leader, as being far superior and a much more effective way to investigate and prosecute domestic abuse. Now, one of the other key things, if we're going to put the victims at the centre of this, is that as soon as you create a standalone offence and you look at it in isolation, you're probably going to have to consider defences to that offence, and you're probably going to come back up face to face with the issue of consent. And that means the whole trial is about the victim and their behaviour. We know that from rape trials. We know that it is a battle in the High Court every day to ensure that rape trials are not all about focused on the victim's behaviour, what they did beforehand, what they did afterwards. And the beauty of the domestic abuse legislation is that it focuses very much on the perpetrator. It is perpetrator-focused legislation with victim-centred outcomes, and that's the difference.
Thank you. So the key point on that I'm getting is you couldn't prosecute both. If there was a standalone offence, you could not indict both because they're using it would be prosecuting the same thing twice.
So that would be a double jeopardy of prosecuting the same crime twice. You could prosecute all of the other aspects of the coercion and control within that abusive relationship and separately prosecute the non-fatal strangulation, but you couldn't if it was. So let's say it was not a domestic abuse case, and someone reports non-fatal strangulation and they don't report anything else, then you can't prosecute an assault and a new offence.
Yes, I understand. Thank you. And another reason that you gave in your evidence for why we might not want to bring in a standalone offence was about sentencing. So it's about at the far end, once the offence has been established. What you've suggested is that the maximum sentence under the common law, or DASA, are higher than in England and Wales, significantly higher.
Yes, although the DASA maximum sentence, I think, is actually the same as Ireland, which I didn't appreciate when I wrote the written submissions.
So the common law sentence is unlimited?
Yes.
And the DASA sentence is up to 14 years?
On indictment, yes, and the majority are prosecuted on indictment. So
that then begs a question, because we heard earlier about a case where the sentence was nowhere near either of those, and that will turn on its own facts, obviously. But does the service have any data then on what is the typical sentence where non-fatal strangulation is proved or as part of the assault? And if it doesn't exist currently, can it be collated so that we as a parliament can understand if a new offence is needed in terms of the sentencing ability?
So sentencing is very much for the judiciary. As I understand it, the Sentencing Council is drafting guidelines specific to domestic abuse at the moment. So that would be something for them to consider. We don't at the moment have a way of counting non-fatal strangulation cases through the justice system, which is something that's causing shared concern. And if there is not a specific offence as a mode to count, and also then each time, so as your colleague, Ms Clark, said earlier, that sometimes there's a specific offence and then for good reasons other charges are still used, we would still have our common law powers and DASA would still be available. So you still need to find a more effective way of counting all of the cases. One way to do it might be to add a marker to police reports where there's evidence of non-fatal strangulation, and that marker can be reviewed by the prosecutor. So if further evidence comes to light and it wasn't on the police report, but then we believe there's reason to add it, we're able to do that. And same when it gets to SCTS, so the Scottish Court Service, they can also amend it if, for example, there was a plea negotiation or if two cases were rolled together and further charges came to light.
I'm very grateful. One final, very small question then on that, adding a marker, because
Sure.
that presumably doesn't require legislation.
No,
so
it doesn't.
On whom?
Just a lot of admin.
And who would the onus be on to do that, to make that improvement?
So I confess I don't know the answer to that. Give me one moment.
We can establish that. I mean, it's a well-trodden path in terms of updating police systems and adding markers to our crime record and our reporting systems. So I could certainly look into that. And
so is this
provide
is something that the police could do on their own volition?
In terms of flagging it through the use of a marker in police reports?
In order to collate the data?
I expect it could be.
Very grateful. Convener.
Very much. Okay. Pauline McNeill and then Ben McPherson.
Thank you very much. Good morning. Dr Forbes explained that very well, so I understand what the dilemma is in terms of might be some public awareness raising of a new offence, but you want to get prosecutions and you want to make sure that as you prosecute you get convictions, and so the law, the content of the law is really important. I wanted to ask you, so in our papers we've been reading that Section 70 of the Domestic Abuse Act in England and Wales, so it sets out a specific offence in 75A, but it includes a defence for consensual strangulation, stating it's a defence for A to show B consented to the strangulation or other act. Now, obviously, there's a caveat about recklessness in there. But does it seem odd to you, Dr Forbes, that if consent is not a defence to assault, as recently confirmed in its Kirkup, I think, VHMA, previously, I think, Smart VHMA, so they wouldn't really work in Scotland then, or would we be over, you know, if we were to legislate in the same way, what would it mean for the issue of consent to assault?
So we have concern that if you consider a specific offence, that would become a discussion point, and we felt it was important to highlight that so that if you are considering a specific offence, that really careful consideration is given to any defences, because a defence of consent is potentially a significant dilution of the current law in Scotland, and given the prevalence of non-fatal strangulation within domestic abusive relationships, we're worried that there would be a lot of, can we call it constructive consent? I think Fiona Drew this morning called it so-called consent.
Yeah.
And we would absolutely agree with her on that we're really worried that there are cases in which people are ostensibly consenting, but they were not in a relationship where they were able to. So Fiona Drew Drewy and I both went to Glasgow University and spoke to Kate Tonkin from the Glasgow Guardian. It's their newspaper. One of the reasons being we wanted to raise awareness of this issue among students. And so to explain this consent point, in Kate's article, she talks about Megan, not her real name, a Glasgow University student. And if I can just read what she said about going on a date. She said, "We went to a river. It was public, a Saturday night. He started kissing me, which I was fine with, but suddenly he had me against a wall with his hand around my throat." She describes feeling trapped. "I was like, I can't say no. I can't fight this. You could squeeze harder and I could be dead. I need to do what you want because you literally have my life in your hands." The journalist then goes on to say at the same time she didn't realise it was an assault. "I covered up the marks with makeup and pretended everything was fine." So if our young people are scared to go on a date, then that is really a pressing issue for this Parliament. But a defence of consent is potentially really quite problematic when you start to think about what that really means.
Thank you very much. Liliana, I know you'll be interested in the issue of the legal point around consent. Do you want to add to that?
Yes, I think there are two further arguments to consider in terms of consent. And one of them will be probably, if you like, the proportionality. And because as it is right now, it's not possible to consent to any type of assault. And if non-fatal strangulation is captured as a standalone offence with a potential defence of consent, then I think it's valid to ask, is it proportional that it's possible to consent to non-fatal strangulation considering the very serious impact that it has in the mental and physical health of the victim, but it's not possible to consent to other less serious type of assault. So I don't have the answer to that, but I think it's something that it's worth to consider. And the second point that I think other members of this evidence session has mentioned are the circumstances in which the consent is provided. I think in the written submission of the petitioner, she mentioned a BBC survey made in 2020, and it says that 40% of UK women aged between 18 and 39 years old reported experience choking, strangulation, or gagging during sex, with 42% feeling pressure into these acts. So at least it creates to me a question on which are the circumstances in which this potential consent is given, and if that can be captured by legislation. So I don't have the answer to that, but I think there are some useful questions that should have thoughtful consideration in case new legislation is introduced.
Thank you very much. Detective Superintendent Lindsay Fisher, I don't know if you would know the answer to this, but in the Northern Irish legislation, do you know if it deals with the question of consent, same as in the English position?
So whenever we introduced the legislation in June 2023, we actually had a specific removal of, excuse me, what sadly had been colloquially referred to as the rough sex defence. So we had already taken the opportunity to make sure that that was removed and that couldn't be used as part of a defence for this type of behaviours. Previously, we had relied on stated cases such as R.V. Brown, which is of some vintage going back to 1993. But there was no statutory provisions at that point. So really, the new legislation within the Justice Act did strengthen our opportunities to move away from that, because we had seen the rough sex defence or the consent defence used even in homicide cases where strangulation was the mode of homicide. So it was very important that was part of our legislative provisions.
Thank you. That's really helpful. I mean, just lastly, I think the sort of conundrum, I think, around this question of the context of domestic violence, and then I read out the survey that with 16 to 34-year-olds indicated, a recent survey, that they had been choked or strangled at least once during consensual sex, and that half of these young people said that they had consented to this. So you've got to assume from that the context is not domestic violence. And that gives me cause for concern. I suppose technically both of the people involved in the Consensual Sex Act would be technically already breaking the law, because you don't have to show injury or harm. And that, we can answer that question, but therefore, before we were to look at any changes to the law, I wonder if you would agree that there's going to have to be a great deal of thought given to public awareness about obviously the impact of strangulation that a lot of people might not be aware of, but that already potentially they are already breaking the law. Or any other thoughts you have about how you deal with that? Dr. Forbes, if you would like to go first. Yeah.
So, in the scenario that you've just given, only the person doing the strangling has committed an offence, not the other party. I think, given what we know and the evidence that you've heard this morning about the potential lethality and just how dangerous this is, that there is a real urgent need for public awareness. We have certainly galvanised our prosecutor training. It has always been a focus of domestic abuse training and different training that prosecutors receive, but we are now rolling out specific training just on non-fatal strangulation, so that cases without injury are still recognised, that the dangers are fully appreciated, to ensure that cases go to the correct forum and that they are seriously dealt with. But we're really worried about lack of prevalence, and I think that I had mentioned in written submissions about the fact that the Scottish Crime and Justice Survey has never asked a question about this, but I understand that your next survey is going to, so that's definitely a welcome step, and we'll give you more information about prevalence. But the young journalist from Glasgow University said that the unit required less pressure than opening a can of Coke to do long-term damage to somebody when you strangle them. And that just is terrifying, and I think that raising awareness amongst young people of just how risky this behaviour is really important.
Thank you. Liliana?
I agree 100% with the comments of Dr. Forbes. I'm not quite sure if people is consenting this type of act. All of them are aware of the serious consequences that it may have for their own health, and in addition, if they are aware of the potential long-term consequences that it may have. So I think maybe not the only one of the more effective way to address this problem is raising public awareness of that, and I think, again, appropriate allocation of resources in those campaigns are crucial for that.
I'd fully echo that as well. I think whilst it's important to have robust legislation and consequences for perpetrators, and I think we already do. As we've discussed this morning, you can't necessarily just arrest and prosecute your way out of a problem, and I think that education piece is really, really important.
Thank you. Lastly, Superintendent Fisher, do you want to add anything?
Yes, I absolutely agree with the comments that have been made. Public awareness is really key across all age groups, because, and it's been reflected about that focus on, school education, which obviously future-proofs safety and awareness. But actually, whenever we think about all of the age and the demographics, we also need to raise awareness of those that are committing those crimes and are having those crimes perpetrated against them now. And I think we have to consider the long-term implications and the harm that can be caused, because would people still consent if they knew that. And we have seen through one of our first publications of domestic homicide review, where strangulation was talked about very early on in a relationship, and it was disclosed, and sadly that did go on to lead to a domestic homicide. So I think we do need to raise awareness and make sure that everybody is aware of the implications, perpetrators as well.
Thank you very much.
Thank you. We've just to make members aware, we've got about 25 minutes left. We will have to close the session at 12:20, and I've still got a number of members wanting to come in. So I would ask for succinct questions and answers so that everyone can ask their questions. So I'll bring in Ben McPherson and then Sharon Dowie.
Thank you, Convener. I'll be as quick as I can. Just first of all, given that they're given evidence today, I just remind Parliament that I'm on the register of the role of Scottish solicitors with the Law Society of Scotland. Much has been covered already that I was going to ask, but just first of all, Dr. Forbes, you've spoken about the unintended consequences with regard to Domestic Abuse Act 2018 if there was a standalone offence. I'm curious also that you cited that example from the discussion you had with the University of Glasgow's newspaper and the example that you just put on the record of someone on a date. In terms of a situation like that, where there's an incident that's not connected with a relationship necessarily, or a period of domestic abuse in a medium to long term situation, but a short term incident, do you feel that the tools that you have available as a prosecutor in terms of being able to prosecute on assault in that instance, you have enough, or is that more challenging?
So the laws of evidence are going to apply whether it's a common law assault or a specific offence. The burden of proof is going to be the same either way. And so the challenge of the fact that that was in private, it was intimate, we're going to face those evidential challenges regardless in that situation. But presently, we would be able to prosecute under the common law and there would be sufficient. But if it was established that there was a relationship between them, then we would, even if that was a single standalone, like you're saying, we would still add a domestic abuse aggravation to that offence as well. But I think one of the things that we have perhaps made a mistake with today is that we have separated those two in discussions all morning. And I would really like to see further work and research on the impact of that and whether those young boys who are strangling on their first date, on their second date, how many of those then go on to have relationships where they have normalised that behaviour, and then what we know about that as a red flag and a danger for homicide, and just how dangerous that behaviour is.
I think that's very helpful to get that on the record, so thanks for stating that out to us. You also talked about the urgent need for greater public awareness, and actually all panel members have spoken about that. I'm conscious of the good work that the Emily Test does in many ways, raising awareness, particularly in educational settings, whether that's in schools or universities or colleges. But are there any plans that you're aware of for a much wider public awareness campaign, given the growing prevalence, worryingly, of this, and also the need to create that awareness that, one, this is dangerous, unacceptable, and you could be prosecuted for this? Because I'm not aware of a Police Scotland campaign or a wider Scottish Government campaign, and it feels to me that there's a strong case that we need one. And I wondered, from Detective Superintendent Lindsay Fisher if there's anything that you've done in Northern Ireland to raise greater public awareness through a specific campaign that we can learn from. I don't know who wants to pick that up first. But,
we routinely and regularly put different campaigns out in and around domestic abuse and sexual harm. We've got our That Guy campaign.
I was going to say
domestic abuse campaigns out every year, and they're constantly subject to refresh and discussion with our corporate communications department. So
just on that, sorry to interrupt you, but I mean the Don't Be That Guy campaign has been very successful and very impactful. I mean, do we need something similarly powerful and creative on this issue?
It certainly couldn't hurt.
Thank you. Sorry to interrupt you. I know you were going to go on to say something else.
No, I mean it certainly couldn't hurt. It's these campaigns are planned well in advance. They take some planning and preparation, but it's definitely something that could be considered. As I say, we refresh them annually.
Thank you. You want to add anything? No. Okay. Understood. Detective Superintendent Lindsay Fisher, is there anything from Northern Ireland that you want to relay to us about any campaigns that you've undertaken there on this issue?
Specifically, whenever we have launched any new legislation, we have provided partners with toolkits. And as part of our toolkit for the non-fatal strangulation offence, we did include some guidance and a short video from our SARC leader, from Professor Hull, which I do think was really helpful because it showed not just the police and the evidence side of the offending, but actually the medical and the forensic aspects. So that was used by our partners within our toolkit. And similarly to Scotland, we have only recently launched our Part of Change campaign, which, although it is only in its 4th month of existence, we have had over 2 million hits across various sites. So again, that has proved really successful and will continue to build and reshape depending on the current trends and legislative changes. So I think it is really important that we do have those bespoke campaigns, but we haven't had a wide governmental-led media policy or campaign specifically on non-fatal strangulation. It would have been included within our domestic abuse offence campaign.
Okay, thank you. Thank you, Camilla.
Sharon Dowie, then Rona Mackay.
Thank you. I think we've heard from the evidence this morning how serious non-fatal strangulation is, and we've also in the submissions from Police Scotland and from COPS heard about a lot of concerns about the detrimental impact of bringing in a standalone offence and unintended consequences. So if the Scottish Government decided not to introduce a standalone offence for NFS, are there any other options available that you think could ensure that the behaviour is adequately addressed by the criminal justice system? And also, I think it was in Police Scotland's submission that they had mentioned an aggravated factor. So again, what your thoughts would be on adding in an aggravating factor for existing offences? If you want to.
So, absolutely. I think if it was feasible to include an aggravating factor, and I appreciate there's some legal considerations around the competence of that, it's something that I think would highlight the severity of this type of behaviour in the criminal justice system. I suppose it's not really for the police to comment on sentencing guidelines as well, but obviously anything that resulted in appropriate consequences for perpetrators would also be welcome.
Is there any other action that you think we should take?
As we've said, I don't think the creation of a standalone offence is going to be particularly helpful. I think we've got our DASA legislation, we've got a suite of other offences and those rare occasions in domestic abuse cases where non-fatal strangulation exists in the absence of other abusive behaviours. But nothing specifically that I'd like to raise here.
Okay, and Dr. Forbes?
So we have some aggravations at the moment So, for example, we can use a domestic abuse aggravation onto many common law offences, and we would also add a child aggravation or a racial aggravation in different cases. Now, if you think about an assault being committed and it being aggravated because it was an assault on a child, or aggravated because the person was assaulted because of their race, then those are the circumstances, examples of circumstances where we add an aggravation. The difficulty with adding an aggravation of non-fatal strangulation is that that is the offence. So you're aggravating an offence. This is quite difficult to explain, but the offence is that somebody has been strangled and then it's aggravated by being strangulation. And that doesn't, we were concerned about the competence of that, if that makes sense. And also, Fiona Drew this morning had raised concern that the aggravation wouldn't have the same, if legislative steps were going to be taken, that the aggravation would not have the same impact.
So see, given your concerns about bringing in a standalone offence, is there something else that we should be doing legislatively? Or do you think the current legislation is fit for purpose, and that we actually just need to, as everybody else has mentioned as well, we need to improve possibly public awareness of it, or maybe look at the training that's given to police when they're going through domestic abuse training? Or is there anything else we can do?
Honestly, if you pass a law tomorrow of non-fatal strangulation, that will have an incredible impact on public awareness. And I wish that I thought that that was the answer, because something needs to be done, and it needs to be done urgently. But we are really concerned about the detrimental impacts, not only on the way that victims would have to give evidence and the difficulties in proving those, but also in relation to establishing links between the non-fatal strangulation within a course of abusive behaviour that ultimately ends in a homicide. For us to be able to prove that that homicide was part of that course of conduct, then we wouldn't want to take that non-fatal strangulation out of that charge. So in terms of all the other areas where we're trying to make progress and improve the way we address domestic abuse, this really would feel like we're moving from Scotland being the global leader in the way that it understands the dynamic of this offending and the toolkit and legislation foundation that we have, to something that would actually create more obstacles. But I do wish that wasn't the case, because it would be a neat solution.
So we would make a huge impact in increasing public
Yes,
awareness.
and Fiona has made a compelling petition today that we all have a lot of empathy for.
But the one thing we don't want is to decrease prosecutions on it.
Yes,
so.
And I can't think of another legislative solution, I'm afraid.
Okay. And one question for Liliana. Unlike the other two submissions we mentioned, your submission says we have a neutral view on the creation of a standalone offence of NFS, but you also go further down. It's the allocation of appropriate resources is critical to ensure the enforcement of new provisions. I wonder if you could tell us a bit more about that. I'm just wondering, does that go down the same line of it's going to be harder to try and prove it, which means you're going to need a lot more resources, not just maybe for the law side, but also from the police side to actually go and get a prosecution?
Yes, that's the case. When we mention that we have a neutral view, is because we see the merits in creating a standalone offence. As I think all of us has mentioned before, it has its benefits, but we also see that there are other offences in the current in the current criminal law that covers those type of offences, and we also foresee potential unintended consequences in the introduction of new legislation. But if the decision is to introduce new legislation, the matter of resources should be considered in order to achieve the purposes that that legislation is aiming to achieve. So we we do not support or not support the introduction of the bill, but we just mention that in case that this is introduced, a careful consideration and resources should be given.
Okay, thank you.
Okay, thank you. Rhona Mackay and then Katie Clark.
Thank you, and good afternoon. I wanted to ask a question of first Detective Superintendent Lindsay Fisher and then Detective Superintendent Adam Brown. Detective Fisher, can you tell me, do your police officers routinely, when they're attending a domestic abuse incident, routinely ask if the complainer has been is alleging non-fatal strangulation? Is that a question that's asked?
It is, yes. We still use the dash questions as it would be used around the rest of the UK. So we are routinely asking that. We're not only looking for the verbal response, but sometimes we will see an automatic response of how maybe a victim will touch at their neck or will think about their response to that. So we are focused specifically on that question, whether as part of the domestic abuse offence, course of conduct, or as a standalone offence.
Okay, thank you. And Detective Brown? Same response.
So the same response that would happen at the front line, at the first point of contact with the victim.
Thank you. So my final question has really been answered, and it was really about awareness and, should the Scottish Government decide not to bring forward legislation, what would the initiatives be? But I think that's been covered in what we've been talking about with awareness. And just in a personal comment, I mean, for the past 9 years since I've been elected, domestic abuse has been the issue that I focused on. I'm convener of the Men's Violence Against Women and Girls Cross-Party Group. And I, until recently, in fact, until Fiona's petition, hadn't heard of this. And I think it's all credit, I just want to say all credit to Fiona and the campaigners for doing this, because it's clearly a growing problem. And I think from what we've gathered today that doing nothing is not an option. So I think it's all credit to campaigners for that. That's fine. Convener, thank you.
Thank you very much. Katie Clark.
Thank you. And I'd like to echo Rhona's comments in terms of the campaigning work that is cutting through. If the political decision was taken to go ahead with a stand-alone offence, does the panel have any further thoughts on the framing of a new offence? Are they saying, from what's been said about defences and consent, that it should be a strict liability offence? How would that operate, given what's been said about rough sex? And whether there was intent to cause harm, or whether it was negligence or recklessness be factors? If there was a decision to go ahead, is there any advice you could give beyond the concerns that you've already given in terms of how you think this would have to be framed? And maybe Dr. Forbes, if she's any thoughts, it may be that you've already expressed yourself fully and expressed your concerns.
So I think our observations on consent are now on record. The common law of assault is an intent to injure, to harm. And so I think probably you would need to... A specific offence would want to have intention, but perhaps not recklessness, because you... But can you just bear with me for a moment?
Of course.
Sorry.
No, that's okay.
Sorry, so I think you would probably want to have intent and recklessness, because you would want... You would not want this to be something that... Whatever you do, you don't want to water down the law that we already have, I think is the key thing to say. So you want to mirror the common law definition of assault and steer... I think that the comments that Liliana made earlier and the observations on consent were helpful.
So you'd be suggesting, if the political decision was taken to go down this path, that there would have to be intent to cause harm or recklessness as to whether there would be harm. That would be and as much as possible.
So I don't think you want either to have any need to cause injury or harm, because it's implicitly harmful.
Okay, I understand what you're saying. Thank you.
Yeah.
Is there any other additions that any of the other panel would want to add?
I have a comment. Maybe it will be more a question for consideration. And I'm aware that there is some evidence from Australia related to the engagement of victims of non-fatal strangulation after the incident happened. And for, I will say, the majority of the cases, the principal reason for not continuing prosecution was the disengagement of the victim with the case. So if new legislation is introduced and if the matter of consent is also considering this new legislation, I think very thoughtful consideration should be given to the impact that this is going to have in the complainer, and as such, the impact that is going to have in the evidence of the case. As we can see from comparable jurisdictions that have similar provisions, that victims tend to disengage, and I'm not quite sure if that's something that US Parliament want to or pursue. So just having very thoughtful consideration on that aspect, I think, will be crucial.
Okay, thank you.
I don't think I could articulate it better, if I'm honest, so I'd echo that. And obviously with those challenges around prosecution and disengagement of victims, those would come at the investigative stage as well.
Okay. I don't know if the Detective Superintendent was wanting to add anything.
I suppose I would just echo the caution that I had outlined in Northern Ireland's previous offence, which was choking, strangulation with intent to commit a further indictable offence. So I think that would just be something to give due consideration to, that had previously proved significantly problematic in securing convictions, which is why we moved into how we now prosecute under the non-fatal strangulation offence.
Okay, thank you very much.
Okay, thank you very much indeed. Okay, I'm going to bring in Liam Kerr just to bring this session to a close with a final question. But before I do so, I just want to let panel members and members know that I have to leave just in a few minutes to attend another commitment. I don't want to curtail this session. I think this is a really important discussion. So with that, I'll be handing over to Liam Kerr, our Deputy Convener, to continue convening the rest of the meeting. So on that, I'll hand over to Liam.
Very grateful, Convener. It's just a very small question to Liliana, arising from something that came up earlier in response to Pauline McNeill's questioning. Liliana, I'm obviously putting this to you as a member of the Law Society, and I remind members that I am a member of the Law Society of Scotland, although I haven't practiced criminal law for over 2 decades. We heard earlier when Pauline McNeill was discussing consent and the suggestion that a standalone offence might be created, but then consent might, I think Dr. Forbes was saying that consent would come in and that potentially dilutes the protections that are there already. What is the requirement of any statutory offence or any standalone offence to have that defence of consent in? Is there something that I'm missing whereby we are obliged to put in a defence of consent to a standalone offence?
I don't have an answer to that right now. I can come back to the committee later because I don't know. I don't have the answer today.
No problem. I'll throw the question to Dr. Forbes then.
I think I'd agree with Liliana. I'm not 100% sure, but I can't think of a reason why. I don't see why you would have to have it.
It just, in responding to Pauline McNeill's question, Easy, it was you, Dr. Forbes, were very clear that if there was a defence of consent, it would dilute it. And it was almost, I felt it was implied that by creating a standalone offence, you would have to have consent. But I think we're not sure if that actually is the case. Is that correct?
The scenario of consent is going to come up in the context of otherwise consensual sexual relations. So I suppose the reason that we thought that it was a live issue is because it's a defence within the Sexual Offences Act of 2009, and this very committee discussed that at the time and specifically agreed that the so-called rough sex defence would not be part of the 2009 Sexual Offences Act, and that because non-fatal strangulation already comprised an offence within our law, and that to bring it within the 2009 Act would then make it subject to a defence of consent, and it was deemed too dangerous to do that. So with that background of this committee's work in mind, I just thought that it might be a live issue in your minds and was wanting to counsel against it.
Thank you. Pauline McNeill, do you want to come back in on that?
Yeah, because I think it is the central question for lawmakers, I suppose, and which is why I probably, on the whole, I have to think about it, but I think what you've said, Dr. Emma Forbes, is really, really important from my point of view about getting this right. And I think the problem is that what I said at the beginning was that how are you going to distinguish then, unless you have sort of common law flexibility and not a statutory offence, is the distinction between the domestic violence context and what we've been hearing, which is formal agreements between couples on something which they've both consented to, which can cause harm, and it would be a really tricky area of law. And then we've also heard which the English position where they've got consent in the law, that must lead to less prosecutions. But the Northern Ireland example is quite interesting as well. So there is, I think, there's a lot to think about.
The issue is that as soon as you're not talking about a domestic abuse case and you're talking about predominantly young people dating, then it's probably happening within the context of consensual intercourse. Otherwise, we would be prosecuting the whole thing as a rape. So let's assume that there's consensual relations between a couple, and then that what they consent to is to have intercourse, but they don't consent to non-fatal strangulation, and then we try to prosecute that on its own. Then, if there's no matter what you do, you're going to have a conversation around. If you try to legislate for that specifically without using the common law, you're going to run back into a discussion on consent, because some of the behaviour was consensual and it was just.
Yes, I understand.
Okay.
And I think there's a lot for us as a committee to.
It's complicated.
It's been a fascinating session. I don't think any members have wished to come back in. And that being so, I will again commend what, certainly for me, and I know for members, has been an extraordinarily, well, a difficult session, but a very, very interesting one, and there's an awful lot for us to discuss and think about moving forward. So with that, I thank you all the witnesses, for attending and for your evidence today. And I close this, but oh no, before I close the meeting, I need to say publicly, our next meeting will be next Wednesday, the 28th of May, and we will begin taking oral evidence into our inquiry into the harm caused by substance misuse in Scottish prisons. So, that being so, we'll now move into private session, and I close the meeting of this committee.